The nuance of this law that sometimes, not only from the police officers and the law enforcement officers' perspective, but from the defense perspective, is to explain that, in fact, this is a two-part process. There are two separate proceedings that arise out of this DUI arrest. I guess the analogy would be they're like two trains running on parallel tracks. They're independent of each other, and when the legislature set this up, they used the model from Minnesota. The statutory summary suspension provision is civil in nature and is separate and distinct from the criminal DUI. And People v. Orth, which everyone should have, prosecutors and defense attorneys in their trial notebook, because this is the main leading case in the state of Illinois as to statutory summary suspension, what it involves, what the burden of proof is. And they set it up this way, and it's important to note that a lot of people believe that they arise out of the same incident, they have the same burden of proof. They do not. The interesting thing about this is that you can have two separate results from two separate hearings on this case. Individual goes to a hearing on their statutory summary suspension provision, and they won based on probable cause. A lot of defense attorneys and the motorists will believe, well, if I won it on probable cause at the statutory summary suspension hearing, I should win it automatically at the criminal proceeding. Not true. And the issues of collateral estoppel and res judicata, importantly, do not apply, in fact, in these proceedings. I don't necessarily agree with it on an intellectual level, but so far that is the law in the state of Illinois. So the disposition of a DUI charge may not contain a disposition of the statutory summary suspension. So if the motorist pleads guilty or is found guilty under People v. Schaefer, and there is no notation about what happened to the statutory summary suspension, keep in mind then that if the Secretary of State issued it and it was 46 days and it was properly filed and there's no hearing on it and it's 90 days past when it was served, the notice, there's going to be a separate finding of enforcing the statutory summary suspension without ever a hearing. Also, there may be a finding of not guilty on the DUI charge, or in fact the DUI charge may be reduced to reckless driving, improper lane usage. Again, the fact that that was done is totally separate from the statutory summary suspension provision and does not in any way, in fact, have or control the statutory summary suspension. As a side note, motorist, in fact, comes in and has the case, does not contest the initial statutory summary suspension. The time frame of the 90 days in which they are able to file for a hearing has run, and then the case is reduced or dismissed. The motorist is not able to go back into court and file a petition to rescind the statutory summary suspension if they are out of the statutory time. And again, alleging, judge, there was a finding of not guilty on the DUI, or judge, the case was reduced to reckless driving or improper lane usage, and therefore you must do something on the statutory summary suspension, is not the law. And the People v. Schold case and People v. Gerke stand for that proposition. Now,